As business owners, we don't necessarily love the FTC, but in our consumer roles, we do love the FTC.
If you're a gym that requires an exit interview to quit, especially for like recreational style tumbling, like tumbling classes and things like that in the cheer industry, I would discourage you from doing that. Contracts don't really matter anymore, right?
Oh, Daniel. Well, no, because the FTC says you have to have this in writing.
Hello, everyone, and welcome to another episode of the Cheer Biz Podcast. I'm your host, Dan Cotton, and we are on with our favorite and most frequent guest, Matt Becker from gymlawyers.com. If you haven't listened to any of the episodes with us before, go back and listen to those after you're done with this episode. But Matt and I always have a grand old time. He was actually just complimenting my new office and how cool it looks in my studio. So if you're not watching on YouTube, go check it out. I'd love more than, 20 views on our YouTube videos. I know a lot of you listen on podcast, which is awesome. Although Matt's probably like, no, don't go check out mine. Because his background, though, is better. It's better.
Is it?
You've got trees in the background, like they're fake trees.
Right.
It's it's giving Oregon vibes, honestly.
I know.
Your pictures are.
That was a lot of the motivation was our newfound love for Oregon. But I just wanted to compliment also that the studio really put your arms back out on the the They look huge.
Yeah, it makes me look more swole. Yeah, it's all lenses. It's all lenses.
Check out my pecs, little man.
So Matt and I were actually just in Vegas this last couple weeks ago at the start of the year at our Next Gen conference in Las Vegas, and we had a grand old time just catching up at his table. But Matt gave a presentation in Vegas to just our Academy members, and he was talking about some new information that was coming down from the FTC that was going to impact all of us. And there was more than one person who left going, oh, poop. I need to make some changes right away on these things. And not because anyone was doing anything malicious, but just we need to comply with the expectations. So, Matt, I'm not going to ask you to do a big introduction of yourself. Again, if you don't know who he is, gymlawyers.com, the best industry resource for legal services in the gym industry. So just go to Matt if you need help.
There it is.
But let's dive into it. What the heck are we talking about? What even is the FTC? Go.
Okay. FTC is the Fair Trade Commission, and it is the branch of the federal government that is designed basically to protect consumers. So as business owners, we don't necessarily love the FTC, but in our consumer roles, we do love the FTC because they require businesses to do a whole bunch of things or not do those things that protect us and our money. On state levels, and we'll get a little bit into state stuff because even though the FTC rule may not actually reach full implementation, which we'll talk about, a lot of states are still doing this stuff, so we still have to be concerned about it. But the FTC looks at consumer problems, and they pass what are called FTC rules. Everybody freaked out about this initially in 2024 when the FTC came out and said non-competes are no longer good. Nobody can have non-competes except very small little circumstances. And everybody was like, oh no. Well, that got struck down. And then in October, the FTC dropped the click to cancel rule, and everybody freaked out. And what we had to do is we had to get on and explain to people, it's just a rule. So this is just a federal body, a governing body that comes out and says, we want to control businesses, especially online businesses, who are using subscription-based models for their services. And these are the restrictions that we want to propose to put on these restriction models. Once the FTC drops this rule, it then, between 10 and 30 days, gets filed with the Federal Registrar's Office. And that's all I can say about the Federal Registrar's Office. I'm not really quite sure what they do, but they file FTC rules. And once they do that, there's about a 180-day period that people can go and start poking holes in this thing. It technically went into law, if you will, in January this month, and everybody has until May 14th of this year to comply. So it is technically implemented. We just all have a period before we need to actually comply. In that time period, people can sue, they have sued, the new presidential administration can kill this thing, a whole bunch of stuff can happen.
Okay. So there's a new rule, and it's the click to cancel rule. I'm assuming that the title is somewhat descriptive of what it means. But see, I don't know if you know this about the cheer industry. So in the cheer industry, we compete. Most of the people listening have competitive cheer gyms. And within competition cheer, there are all sorts of rules. And there are rules of what you can perform in each level and all the legalities. But the key is, all good cheer coaches know you find the gray area and you don't break the rule. You just go outside of whatever it constrains. Right. So knowing that that's how we think, can you break down the rule for us and help us know what are the areas we have to, what do we have to do? What do we have to follow? So if and when there isn't some sort of lawsuit that stops this thing from going into true effect, we can be compliant.
Yeah, sure. And I love hanging out in the gray area because it's the fun aspect of the black and white law is to figure out, okay, well, how do we not worry about that? And as we get closer to its actual implementation and we see, like, are there going to be any changes to the law? We'll have a better idea of how we can work in that gray. But right now, here's what we have to be worried about. There's actually two pieces to this law. There's the negative option rule and the click to cancel. Most people know about click to cancel, but let's bump to the other side just for a second. So the negative option rule basically says if you're going to give people the option to sign up for a subscription-based service, then there has to be, between the time that they sign up and by the time that their subscription service kicks into play, if there's a period in there, there must be another affirmative step by the consumer to confirm that they want to go into the subscription-based service. What does that look like? Okay, so I come to your gym and I go in through your system and you use what? iClass Pro? Am I right on that?
That is what we use, yes.
Okay, I can go through your website and I can sign up, just like I could if I was going to sign up for Netflix or Hulu or some other online-based service, right? I can go through the website and I can sign up. I don't have to come in and sit down with you or anything else. And then, I don't know if you do this, I'm just going to say, from this point, you give me a 1-week trial. And as part of my sign up, I have to implement my kid's sign up. I have to put my credit card information in there and everything else. If I don't do anything, if I take a negative option, I do nothing, at the end of those 7 weeks, you're going to start, 7 days, you're going to start billing me on a monthly recurring basis. Mm-hmm. Okay. The FTC says, no, you can't do that anymore. If I can just sign up like that online and I get a trial period, at like day 6 or 7, I need to take another affirmative step to say, okay, cool, I want to continue into the monthly subscription.
That I think does have some significant correlation to things that we do in our cheer gyms. It's not abnormal to do a trial period, to sell a paid trial membership for people. But 2 years ago, maybe more, I think it was 3 years ago, there was a lot of discussion because the conversion process was really laborious and annoying to say, we're just going to go to an automatic conversion where when you sign up for the trial, unless you cancel, you just transition to the membership-based pricing and you're just into your membership. So what I hear you saying is that is now no longer would be an option. If you're offering a paid trial, you have to have that positive affirmation of, yes, please transition me into a full membership that is on a subscription basis.
That's right.
What if you don't call it a trial?
What are you going to call it?
Like, what if you're just signing up for the program? Like, what if you just sign up for a membership? I don't have to have a positive affirmation in that case, would I? If I say you're signing up for a monthly reoccurring membership?
And you don't give them like 7-day free or something like that?
Yeah, there's no caveat. Maybe you could say you get a discount on your first month, or you could have a purchasing incentive. You get a t-shirt when you register. Do they still need another positive affirmation well, you said, when I said a discount. So if you said 20% off your first month, do you need a positive affirmation then? Because in the beginning you said it's the first month at 20% off, even though you didn't describe it as any sort of trial period. It was just a discount on the initial enrollment.
Yep. You read my mind. That's a potential gray area on this one, unless you're in California. Because as we're going to kind of, I know, I love crapping on California, even though I live there, but, and I love the state, and I think it's all good stuff, but it is like, really, you regulate that? But anyway, so peppered in here is going to be little state things that we have to be concerned about too. And that's one that we get into with California. So California says if you offer a discounted rate on a subscription-based service in order to convince somebody to join, you have to give them, and don't quote me on it, I think it's 30 days, but you have to give them X amount of time notice that it's going to go up to a higher rate. I'm not aware that the FTC's negative option rule has that at the moment. So that's a potential gray area that gym owners could work into here is, I'm not going to give you a free month, but I'll give you a discounted month to try it out.
Yeah, and we don't even verbalize it as try it out. Like, so we just we're ending, like today. January was our 20% off your first month. Enroll in our membership, and your first month is 20% off. So their first payment is just less. And so I just would want to make sure that we are staying above board on that process. Obviously, it's not in effect yet, but generally speaking, although the FTC makes mistakes, I try to I try to look at what the intent is behind the rule, which is ultimately to protect the consumer from shady practices. And I don't want to do shady practices in my business. So, okay. So there's
other gyms on doing shady practices.
Certainly don't want to do that one. So there's the negative option rule.
Yep.
I'm assuming that there's some sort of another rule beyond the negative option.
No, it's just click to cancel. No. So that's the other half of this. Yep.
So what does that mean though? So obviously that they can click a button to cancel, but I was not in your class, unfortunately. Ironically, I was working on my landing page for enrolling people when you were giving your class. But I remember someone came out and said something about a certain number of steps that, like, it can't be buried.
Oh, I don't know.
Super deep.
Oh, yeah, okay.
Into a website.
Yeah. I got what they're talking about. In its most basic form, the click to cancel means for however easy it was to sign up, it has to be equal or easier to cancel. So I always pick on Netflix, and I swear one of these days, like, Netflix is going to call and be like, "Stop picking on us. We're in compliant." I'm not saying Netflix isn't compliant. I'm just saying, like,
it's a subscription that everyone has.
It's an easy subscription-based service that everybody understands, right? Okay, so let's say we can go into Netflix, and all I have to do is I go on the website and I put in my credit card information. I click a button. Boom. I have my service. What this is going to say is, in that instance, it should be just as easy for me to go right back in my Netflix profile and click another button, and I'm unsubscribed. There's no waiting period. There's no approval period. I don't have to, like, go through this and email this and talk to this person, get a phone call from this person in order to cancel. I can just click a button and I'm done. That's it in its most basic form.
Is there anything wrong with if you require some sort of a sign-up form, name, email, address, credit card, basic information to sign up? Is there something wrong with having someone either log into an account and then click that button, or fill out a cancellation form that is their name and email and phone number, and that they're, checking a box, understanding that their cancellation is effective immediately, etc., and fill that out? Or is that too laborious?
Right. So our understanding of it at this point is that could be too laborious. So let me go down through this in like 3 different iterations. All right. The first one is the gym allows you to sign up online without interacting with anybody, but then has to email the gym in order to cancel. It would be like, well, online is online, right? No, that's too much. If they didn't have to interact with anybody to sign up, they shouldn't have to interact with anybody to cancel, right? The second level to this is, as you said, well, what if I just use a website form? So I can go in and I can put in my information, click a button, I've signed up. But then if I go in and I put in my information and click a button through a website cancellation form, wouldn't that be enough? The answer to that is, if it's an automatic cancellation, then yes, that's okay. But if that's more or less a request form that then requires the manual cancellation of that membership, that's not going to be enough. So some of these client management softwares are having to update that allow for some sort of integrated website form for cancellation are going to have to update to allow that to be an immediate affirmative cancellation. Okay. Not require human involvement.
So my curiosity on that is the level of human involvement is how do they know? It's kind of the question, because if someone signs up for my program, actually, I don't make them go through iClass because I think iClass asks for too much and I don't want them to navigate away from my website. So I use a very basic form. It does charge them, but there is still a manual process on our end to put them into our database system, into iClass, and enroll them in the class and do all of that. So there's a manual step. So them submitting a form would require a manual. If they could go into their iClass account and cancel though as well, but it would require someone to click a button on our end and say, yes, stop this payment, because it doesn't necessarily, the systems don't necessarily talk to one another.
Yeah. Yeah. And I think that kind of a thing would be okay. The only thing that I would recommend in an instance like that is somewhere within the sign up form, like maybe you have like, if you could add like a little checkbox acknowledgement, like right before they like sign or submit or whatever they do, that says like, please note that the remainder of the setup of your membership requires the manual functions of somebody within the company, and this may delay the start of your membership. It wouldn't, because it's
ours
like,
kind of does.
Okay,
we would have to change the verbiage, but it basically says your membership is not fully active until you speak to our front desk and they confirm your class and they confirm that there's availability in those classes. So
yeah, I think the only area where you might, and like anybody who wants to like pick this apart would really have to fight for this. I think if I were to get like really nitty gritty on that, I think the only I think I heard you say it does submit the payment.
It does.
And then you guys have to go do something else. Yeah.
Mm-hmm.
Yeah. That might be like the only area where that would be an issue. But otherwise, from what we understand right now, that would be fine. You require some sort of manual affirmation for them to sign up. So you're going to require some sort of manual affirmation in order for them to cancel. That should be okay.
So now what if I'm a gym, and I'm not going to, we'll talk about whether or not I recommend this. What if I'm a gym and I go, well, that sounds like a lot of work. I don't want to do that. So I'm just not going to allow people to sign up online. And if you want to sign up, you have to call, or you have to physically come in. You've got to do some sort of like a personal in-person onboarding before we're going to allow you to join. And then we can require you to email or call for cancellation.
Yes. And that's what a lot of like other industries, like the CrossFit industry, personal training, functional fitness, they require these in-person consultation or intros. And from our perspective and understanding, if they're going to require somebody to come in and sit down, but then allow them to cancel via email, that I would argue is easier. It's either has to be equal to or easier to cancel. And so an email or a website form would be just as easy. They're going to require manual sign up, and that's a easier way for somebody to cancel. So I think in that instance, those gyms are going to be okay.
Got it. Okay. Now I will say, I'm going to soapbox for 2 seconds. I do not recommend that you use that methodology to enroll people in your gym. I think it does work for CrossFit and functional fitness potentially, but I think from a cheer gym perspective, get your website working for you and selling for you so people are enrolling online automated. You can build those processes in, and don't let a click to cancel issue make it so you don't have your cheapest employee be your website. That's my personal opinion.
Make it easy. Right.
Make it simple.
Third instance in which we see this sort of like the third iteration is our gyms. And again, I don't see this so much in your industry, but gyms that require some sort of exit interview. That's the other area, or one of the other areas where we're seeing this impacted. Because I just said, like, if you're going to use a website form, if all I had to do is click a button to start and a website form, then technically put in my information, I click a button, it should automatically cancel. Gyms sometimes will do this exit interview thing. So I submit my request to cancel, and then somebody calls me and says, "Hey Matt, so we got your notice of cancellation. Why don't we have an exit interview here? Why don't you come in and sit down with me for 30 minutes?" And the gym is essentially going to try to convince them to stay. FTC rule now says, nope, can't do that. As soon as that submission is processed, as soon as it's sent in, assuming it's equal to or easier than it was to sign up, the gym must then take the affirmative step of canceling that membership. Then I can call the member and try to convince them to come back. I can't try to convince them to stay. What's interesting is New York is about to release a law in February that seems to say a gym has to cancel a membership within 10 days of the receipt of notice of cancellation, which is, it could upend a few gyms in New York that currently have 15, 30-day notices within their membership agreements. But what I'm curious about, and we'll get in the weeds a little bit on the law, is whenever a federal law is released, all states must abide by at least that minimum standard.
Right. Then they can be more restrictive.
Additional protections, right, for your old profession, like search and seizures. Federal law says in these instances, I don't remember, maybe it was like it wasn't cars. You don't necessarily have an expectation of privacy within a car so much, but then individual states can say, yes, we do. We believe that you have an expectation of privacy within your car because it provides additional protections than the feds. In this instance, I think New York currently isn't going to provide as much protection as the FTC is going to provide. So that law is essentially going to end, the New York law is essentially going to end up trumped by the FTC rule if it continues into implementation in May. And I'm really curious to see how this is going to change a bunch of states' health club acts, because the FTC is going to end up providing additional or higher protection than what the state law is providing.
You mentioned the monthly membership, and if someone cancels, and that cancellation needs to be effective immediately. And I just want to make sure we provide clarification to all the listeners, because I believe I understand, but I'm going to check on my understanding here. So someone cancels, that cancellation goes into effect immediately, meaning I stop all future billing. That's really what that cancellation going into effect means. They're not going to get billed again. But let's say I have a client who we're about to run February dues for our memberships. So they get charged in February, and then the 7th they cancel for March. They say, hey, we're canceling our membership, but they still, I would stop all future payments, but they still attend the rest of February. And that's not me saying, nope, you've canceled, you're done, even though you paid for this month. I'm not violating that rule by allowing them to continue out the membership they've already paid for.
That's correct. Yes. Yep. That's correct.
They can continue. And during that time, I can try and convince them to change their mind or see if we can make something work and then restart that membership. That doesn't violate any sort of rule. The biggest key is future billing has to be stopped.
That's correct. Yep.
That would be something we would recommend people do is talk to their clients. If there's a lead time on someone canceling, see if you can find the problem and fix it before that actual cancellation time of their membership is now over happens. You talking about the exit interviews made me think of that. If you're a gym that requires an exit interview to quit, especially for like recreational style tumbling, like tumbling classes and things like that in the cheer industry, I would discourage you from doing that. The least of which being, it's just a lot of freaking work. Like you're going to be having a lot of meetings to talk to people to have them say, well, Sarah's starting soccer and the time's So just save yourself the time.
Another area where I think gyms are going to get impacted with this is when they have those cancellation windows. When they say, like, you have to let me know 15 days in advance of my next payment or 30 days in advance of my next payment. Because one, the FTC is going to say, well, it has to be immediate cancellation. And two, if all I had to do was, even if I have to come in and sit down with you, if all I had to do was come in and sit down with you for 30 or 45 minutes in order to sign up, why do I have to give you 30 days advance notice of my next billing date in order to cancel? And that is going to just send shocks, because again, not so much in this industry. These guys, your clients in cheer and gymnastics, they're usually pretty good at like, just let me know prior to your next payment and you're okay.
You'd be shocked. Most of the people within Next Gen who work with our academy follow those kind of rules because we do recommend them. It is actually very common. I mean, I think you'd work with a lot of cheer industries. The amount of gyms that still have cancellation penalties of massive amounts of money that they enforce on people. 30-day cancellation. I've seen gyms say that they require 60-day notice to drop from
We've written
a class.
Of those.
Yeah, it's just I think those are definitely goodbye.
Yeah. It will. And you're right. We do see it in your industry. It's more of a shock to see that in the industry versus the flip of over in like your adult fitness. It's more of a shock to see somebody who doesn't require some sort of 30-day advance notice of cancellation. And so, there's going to be some waves there. But to another point that you made, Dan, like you were talking about talking with the customer. I'm going to coin this. I have 11 more months to get this hashtag somewhere, that 2025 is going to be the year of the consumer, which is not a hashtag, but somebody's going to say it. And that's my thing, because, we saw it happening in 2024 and it's just going to continue in 2025. I've peppered in that like even individual states are doing this. California is updating. I think it was Minnesota, one of the M states in the middle there, essentially just updated to mirror the FTC rule. So even if the FTC rule doesn't or gets overturned or gets blocked, that state, it's an exact carbon copy of it. We're no longer going to be able to just rely solely on the fact that, yes, you have a contract with my gym in order to pay me. And that's still a legal thing that you're required to have if you're going to be doing automatic recurring payments, etc. But the conversations, and you guys do a great job of this at NGGO already, but pushing the gym owner to have those conversations with the parents, with the gym, or with the clients, with the members, it's just going to become so much more important because outside of those conversations, you're not going to have a ton of control over forcing people to stay or forcing people to give you a last payment or forcing people to pay that quitter's fee or not getting a chargeback or not getting a refund. We need to put the energy toward making our people happy. And it's, the consumer is always correct mentality than trying to very easily make money so that we don't have to have any headaches.
So loaded question for the gym lawyer. So contracts don't really matter anymore, right?
Oh, Daniel. All right.
I mean, right? Why do I need a contract if I don't have any cancellation provisions? And like, why should we still have contracts? And if we do already have a contract, we're probably going to need it edited if
that's true,
if they're still valid. So convince me, attorney, that I actually need a contract. It sounds like the FTC says, hey, YOLO, cancel people's memberships and you're good.
Well, no, because the FTC says you have to have this in writing. States have laws that say, if I'm going to take a client's money, I have to have something in writing that client is signing, agreeing to give me money. So the was that it? Did I convince you?
No. I'm still going to be difficult.
Another aspect of the FTC rule is there now has to be an additional affirmative acknowledgement of payment authorization on a recurring basis. So right now, this goes, with iClass Pro, with Jackrabbit, this doesn't become an issue because we can put individual acknowledgements in there. It's fine. But again, when we're over in like the other industry, they're going to sit down and let's say we draft a membership agreement for somebody that's 10 pages long. They sit down and they slap that 10 pages down in front of the client and the client signs and they're done. And the FTC says, yes, I have a 3-page payment authorization within that membership agreement, but it's not going to be enough that they just acknowledge at the bottom. There has to be either an additional acknowledgement within that agreement that they're acknowledging, or I have to present an entirely separate payment authorization form to the client that the client is then going to sign. So it's not enough just to say, well, contracts aren't enforceable. You are required by law to have them. And if you don't have them, then one, you've got nothing enforceable. You technically can't legally take payments off of your clients. And if you're caught, states can shut you down. They can charge you with criminal offenses and the feds will shut you down. So we're just trying to help the gyms protect themselves.
But what you're saying sounds like a lot of work. So what if I'm just trying to be difficult? I don't really have anything. It sounds like a lot of work. I mean, like I'm just sitting here thinking, okay, man, gosh, I hear the average gym owner going, how am I going to have enough time to make sure all these people initial every box and sign all these things? And you gave kind of the caveat of, well, have a system that requires those check boxes that people have to check when they set it up. And that's one of the things even that we do in creating someone's account. We still require them to go on and set up their payment process. So they still have to go in and enter their card information and check those acknowledgments for like the final completion step of their account, because I don't want to touch their credit card. I would rather them enter it themselves, and I want those acknowledgments. But
there's another topic we could talk about, PCI compliance. But anyway, I won't digress. Go ahead.
Well, Pete, what's PCI compliance?
If you're going to start to gather the credit card information from your clients in anything other than your client management software, coming out in March, there's going to be a whole lots of steps and other teachings and certifications and tutorials and everything that are going to be required by your staff. If, let's say, a parent comes in and says, here's my credit card, and that staff member takes and writes it down on a piece of paper, don't do it. Just don't do it, because the PCI requirements, again, federal statutes here, are going to say, like, you really got to protect that. Put it in your client management software, because then iClass, Jackrabbit, they have to maintain the PCI compliance, and you don't have to worry about it.
And they have systems that do that. They have vault systems that they pay for and do that quite well. And yeah, I mean, I remember way back in the day when I first opened my gym. Well, we technically bought it. The old paperwork, people literally wrote their credit card down on a piece of paper, and then we put that in a file.
Yeah.
Like, and now I can't even imagine doing that one. So much work.
I don't want it. I don't want it.
Yeah. And like, I don't want it. I want the last 4 digits only to confirm that it's yours. And then I don't want any other information. Just please don't tell it to me. Okay. So we have to be able to click to cancel. We can't have a negative confirmation of continuing a membership. So what would be the cleanest way to enroll a new member and disenroll someone? So like, what are the steps that you would say from a legal perspective someone should go through for an enrollment to get a monthly reoccurring membership?
Okay. Assuming you want to do online enrollment at your suggestion so that you have a free employee.
Yes. I mean, obviously you could say, come in, fill out a contract, initial the different parts, and then good to go.
So, I mean, there's a cost. I'll go on a soapbox for a second, because you were sort of picking holes at me about like, well, I'm a gym owner, I don't want to do this stuff.
Yeah.
I mean, there's a cost to doing business. And I may have said it on this podcast before, but I started saying it late last year that, as business owners, we don't get to wait until we have an issue with the law in order to worry about whether or not we're following the law. If you come and you charge me with a crime, then I call a criminal defense attorney. If you and I get in a car accident, then I call a personal injury attorney. And unfortunately, business owners, they never really are explained this distinction. So they think they can continue to just wait until there's a problem, and then they'll call me and they'll say, I got a charge back, and I'll go, okay, well, where's your membership agreement? And they say, we don't have one. I mean, well, bye. Like, I can't work with that. So when we're business owners, like, we have to be worried about preventing the lawsuit from happening. We have to be worried about preventing that issue from ever arising. And the only way that we can do that is by making sure we're following the laws as business owners. And that's called legal compliance. And if you want to be a business owner, that's a great thing. I can't imagine going and working for anybody else, because I've been my own business owner since I graduated law school back in 2009. And it's a wonderful thing, but that's part of it, is you have to be worried about these things. You have to be concerned, as much concerned about this as you are about the next marketing strategy you're going to use to bring in a bunch of new members. There's just some element to it that, like, you got to worry about it, and you have to be on there. And you'll know, as much as I do, Dan, that the gym owner who calls you and says, I have all of these systems in place, is a gym owner that's operating at a higher effective hourly rate, is making more money, has more security, has a gym that is giving them wealth and able to be sold at some point for a big asset. Versus the gym owner that comes in and says, well, I don't want to do all that crap because contracts aren't enforceable anyway and it's too much headache, yada, yada, yada. Those are the ones who are constantly calling you guys and complaining that they're having headaches because they're not treating their business as a formal business. Is that fair?
I would say that is all fair. Yes.
Okay. Now, what was the answer? What was the question I was supposed to
So
answer?
back to my original question, because we just had that was trademarked by Matt Becker Inc. That entire statement, so not to be used or resold. The original question was, knowing that there's a cost of doing business, and I'm assuming that wasn't a soapbox of saying don't enroll people online, because I don't think that's what you were getting at, but how, if we're not going to follow the base procedure of everyone enrolls by coming in the building and physically signing a contract and picking exactly what they want off of the menu, which would be a very clean way of doing it, but not overly effective from a marketing perspective, a sales perspective, a time management perspective. So if we're going to do a online enrollment process, what would you recommend be the steps to ensure that we're compliant on the front end? And then I think we understand the back end steps, which is just simple. It should be no less laborious, no less difficult than the enrollment process. So what would you recommend would be kind of your steps for enrolling a new member to ensure we're staying in alignment with the FTC, we're getting contracts signed? Like, how would you recommend it?
So to streamline that, use a service that's already set up to do that. So again, like, we're not being paid by constantly saying the words iClass Pro and Jackrabbit. And there are others out there. There was another one that was at your conference, Full Out.
Full
right?
Out? Yeah. I have no experience with them at all.
Yeah, and I've never used any of these services. I just know them through working with you guys and giving webinars and seeing their services and everything else. But the point is, like, they set it up so that you can integrate this into your website and somebody can come in and go through your website to sign up. Okay, great. Super easy way. You said free employee helps you do it in order to get people to sign up. Go through it online, and then they'll get presented your tuition policies and your terms and agreements and everything else. And you can organize that so they have to acknowledge each one, even separately that authorized recurring payment authorization. Parents acknowledge it at the end, and then they're in. And then all you have to do is make sure that the system is then set up so that if they want to cancel, all they have to do is go into their parent portal and click a button and it cancels their membership. And it would be that smooth.
What if you utilize a system that doesn't allow you to upload all of your custom contract language and everything else? What if you have to, it isn't that robust?
I think the problem that you're going to run into there is if you take the payment before you get something signed. If you take a payment and they're locked into this before they've agreed to be locked into it in writing, I mean, it's not going to be the end of the world as long as you do it quickly. It's just not ideal. So you would have to come up with a procedure where, like, as soon as that enrollment comes in, something like emails them, say a PandaDoc or a DocuSign or a Smart Waiver, their electronics, their contract in order to be electronically signed.
Okay.
The problem there is if the client then reads that and they don't like it, they can then, they would be able to just cancel right on the spot.
I remember at one point we had talked and you had said, wet signature is the gold standard. So how do you feel about the checkbox signature, like the checkbox and then them typing in their name, and or the forms that we use on our website that aren't through iClass? We can put in terms and conditions. So we could put our whole contract in there and they could acknowledge each like key category. And then they can sign either with their finger or with their mouse, and they can actually put their signature in to sign saying they've accepted. Is that up to standard? Is that something that would be acceptable?
Yeah. So again, wet signature, pen pad, the best. Beyond that, pretty much every court across the U.S. Has accepted 3 different types of e-signatures as being as legitimate as a wet signature. It's just their level of proof, if you will, on who actually signed. So at the bottom, we'll say at the very bottom is it's acceptable, but we don't love it, which is the click button acknowledgement. Because yes, we can track, the IP address. We can track probably some sort of time stamping. We know when it happens. We know somebody affirmatively clicked that box. But it does leave open the door to somebody to say, well, I don't
My
know who
dog clicked
did
it.
click it. It wasn't me.
Yeah.
Okay.
It was my 6-month-old playing on the
Right.
computer.
Or I see this, like, I would imagine this happens perhaps in your industry where the 12-year-old is mom or dad's out making dinner. The 12-year-old's in here like, hey, mom, can I sign up for this? Yes. Okay, go to acknowledge mom stuff, and they're in. Right. Mom and
Credit
dad
card's
never
already
agreed to do it.
saved in the profile.
It's right there.
They just click the button. Yeah.
So that's sort of like, is it enforceable? Yes, it can be difficult. Next up is the type name acknowledgement. So you get to the end, you acknowledge everything, you affirmatively type your name, you click the button, off it goes. Similar and like it's a little bit better because at least you have somebody like typing their full name. If some fraudulent person doesn't know the full name, they can't type it in, kind of a thing. But still kind of raises the same issue as the original one, which is like, did the 12-year-old child type in mom or dad's name in order to do this? Okay. The top is the actual signing with your finger or a trackpad or a stylus, which then you can put in front of somebody just as you could a wet signature and say, isn't this your signature? And most of these systems now also have a click box that says, by clicking this box, I acknowledge that this is my signature, and off it goes. Still has the opportunity that the 12-year-old could do that on behalf of mom and dad. But I could then put that in front of you and say, hey, Dan, isn't this your signature? And you say, no, it's not. And I say, oh, who's fraudulently writing your signature then? And you don't look very good. So that's our top standard.
All very fascinating information. Here's just, I'm just throwing this one at you. And this is where we've kind of gone off the beaten path. I think we're still talking a little bit FTC, but what about if you sell and enroll people over the phone? What if I'm doing all the entry and someone calls and they're like, I want to get signed up. And we're like, okay, great. Let me create an account for you. And we're creating an account, but we get to that acknowledgements phase and they have to acknowledge how does one do that and take a card and do this stuff because I don't want to go through and, do I read it to the person and say, do you understand that? And do we need to have that recorded? Like, what would be your recommendation there?
Ideally, and nobody's going to do this, you're going to have it recorded because you cannot. Technically, doing it over the phone is really dicey. I would not be comfortable filling in this contractual information, essentially acknowledging on your behalf over the phone, unless I've recorded you saying yes. And I'm sure there's other companies that do this, but the only one that I ever remember doing this was SiriusXM. Whenever you call in and you sign up for SiriusXM, they say, okay, hold on a second. We're recording this call and I need to read you a series of acknowledgments for you to acknowledge so that we can go ahead and authorize your payment over the phone. And then it would be like 10 different things. That's essentially, if you're going to try to do that and you really want to protect yourself, that's the level to do it. The easier way to do that, but perhaps, the more laborious way is you go ahead and you say, okay, I want to sign up, and I take all of your information. I say, great, this is wonderful. What's your email address? I'm going to email you our contract right now. Let's go ahead, take a look at it, sign it. We're good to go. And now we have the actual acknowledgement. But phone stuff can be tricky.
Okay. What if it's not a reoccurring membership? What if it's a one-off purchase and you're taking a card over the phone? You don't need to worry about any of that.
No. We might have some PCI compliance questions, but
sure,
the whole FTC goes out the window because there's no subscription-based service here. There's nothing to cancel. It's just a one-time thing.
So it's so subscription-based. But we have that actually pretty frequently. We have people call fairly frequently our business and say, hey, I want to sign up for classes. And we want to obviously get them closed while they're on the phone. And so we'll just create their profile. So I want to make sure that we stay within that compliance. Would a worst case scenario be have them sign something acknowledging it when they come in, or like you said, email them a contract saying, hey, I'm going to send you a contract. Will you just acknowledge these things and sign and send it back? Like, I'm trying to think of how you logistically do that. Because the last thing I want to do is be like, yeah, you can totally sign up. Here, go to this web address and then do this on the phone with me. Like, I'd rather just do it for them. It's much quicker, makes it more convenient for the customer. But I also understand them wanting to protect the customer.
Well, you're still going to have that person sign a waiver. So you're still going to ask that person to sign something. So you can still take their credit card information over the phone, put it in the system, say, okay, great, what membership do you want? Okay, cool. I went ahead and I signed you up. First day when you come in, we're going to have you sign a liability waiver and just an acknowledgement that we are indeed able to take this payment on a recurring basis. And ideally, again, they come in and then the membership starts, then they get charged. But again, this is just things that may have to wash themselves out a little bit.
Yeah. Generally speaking, if you were to, let's say, as long as, I know we're guessing here, right? But do you think the courts would look favorably if you said, hey, if they had called, and we've even done this, if they call back and cancel before they come in, we just refund their money. We cancel the membership, it's refunded. So then it's at least not looking like you're taking people's money and then not getting them started quickly without that confirmation that you can take the money beyond. I don't know. I'm just trying to think of how you would protect yourself if you ever were in front of a judge.
One-offs, two-offs, a couple of times is not going to be a huge deal for a gym owner. It's when these processes just get rotely put in there and they never get checked, they never get tested, they just set it and forget it. And it turns out that 500 members later, somebody makes an issue of it. And then it comes in front of a court system that, the gym owner has been charging all of these improperly or hasn't been compliant with federal law or whatever. And we've got 500, we've got 1,000 members who are now all ticked off and notified that, hey, there's been a consumer issue here. We're going to sue the pants off of this gym in a class action lawsuit. You guys all sign on here and we'll get you some of your money back. That's where the gym owner is going to get really potentially exposed. And the unfortunate thing is, again, in your industry, is a really successful gym owner could have this happen because they're signing kids up so frequently, so quickly over a period of years that number can rise up to that level relatively quickly.
Yeah, that's slightly terrifying. For a gym owner who's thinking, okay, maybe I haven't done this to standard yet. Here goes my shameless plug. If you don't think you've been doing this to standard, then book a call with Matt and you can go over your processes. And I will tell you, him and his team, because he's got a growing team, they're not going to sit there and talk down to you. They're going to listen. They're going to say, hey, these are the things we need to make adjustments on. And they're going to give you actionable steps contractually that you can set up and make those changes in your business. So good job. You've successfully made it look like I need to redo all my contracts, which means you're going to have some work to do here. So expect my email. Because you did all my contracts, but they all had cancellation policies and all that stuff in them. So
that was fine a few years ago.
Yeah, it was all good. Granted, I don't think we were definitely more of the hey, cancel before your next billing date and just stop your billing. Okay, interesting. For all of you listening, you should know that at the start, before we started the episode, we had 3 different topics, and we were like, I think we could cover 2 in one. We have about an hour and 10. We can totally get through it. We didn't. We do not have time to go into setting up an LLC and a nonprofit booster club. So that is on the docket for those of you that are listening. We're going to be sitting down talking booster clubs, and eventually we're going to do a long episode on wealth protection, asset wealth protection.
Yeah, that's right. So we're sort of, I wouldn't say we're necessarily addressing or changing our message, because we've always been trying to help gym owners protect their businesses through the legal side of their business. But over the last 3 years, I think the message that has come out is you need a liability waiver or else somebody is going to sue your pants off. And that's not the scare tactic that we're necessarily trying to promote to gym owners. So, I mean, it is true, but that's not necessarily the message. The message is we're all business owners. We didn't go into business for charity. We didn't go into business to put all of this time, money, and effort into something just to have it ripped away from us. We went into business because we saw an opportunity by which we could make money. And I want to make money individually. Dan, you want to make money individually. We want to buy houses. We want to buy boats. We want to have big bank accounts, whatever it is. And what we really do is we help gym owners protect their business so that they can then use that business to amass their wealth and then do things with that wealth. So we want to come back and talk about this is actually what we're doing. We're isolating liability. We're setting up a gym so that you can grow it and grow it and grow it, and then take all of the profit and go do something with it. We're not just saying like, give us your waiver so that you don't, or give us your lease so you don't end up with a problem with your landlord. It's what are we actually protecting?
I love it. I love it. That's going to be an interesting conversation because it's not talked about very much in the cheer industry. Most people's long-term plan in cheer is die in the gym.
Which you can, but we still want to make you, we still want to grow your wealth to do that.
Which you can. But the amount of people that you go, hey, what's your like long-term, like what's your retirement plan? What's your like next steps? They're like, what do you mean?
Yeah.
We've got tryouts in 6 months. Is that what you mean? They're focused on the very near term and not as much the far. And there are some people who plan for retirement and do a really good job, but I would not say that that's the norm in the industry for gym owners. So I'm really excited to talk about that with you. So thank you, Matt. As always, it's a great time. You make what could be very boring stuff very interesting. And it's a blast to kind of chat through these things. And I do want to echo or emphasize that the world's not ending. This, one, it hasn't even taken effect yet. And two, even if it does, it's going to require some small changes on your part, but you should be able to execute all of them pretty simply and stay within the rules and do things the right way. Don't stress out. Just know that you might have a little work to do.
Oh, I didn't mean to.
It is always a pleasure. There. No, you were trying to cut me off. I see. Yeah, those are attorney tactics.
The listeners will thank me.
That's a trial attorney approach. Jeez Louise. Asked and answered.
Thank you, Dan.
Counselor.
It's always a pleasure to come on and chat with you.
Yes, it is. All right. Thank you. And everyone, we will catch you on the next episode.